I am going to go ahead and introduce our guest speaker today. And so today we have Tiffany K with us, who is the owner and founder of Chiu Law. She's been practicing for over 10 years, representing clients in various life stages with different levels of wealth. Tiffany's handled matters in her estate planning practice ranging from living trusts for young families, building wealth, to retirees with transfer tax concerns. Tiffany's breadth of experience gives her a unique and well-rounded perspective on the scenarios her clients encounter when creating their own estate plans. She's helped clients navigate situations involving distribution of assets in blended families, planning for wayward children, nominating guardians for minor children, and dividing a family business among the owner's descendants. Additionally, Tiffany's prior experience as a tax attorney helps her identify tax savings opportunities to minimize estate taxes. In addition to estate planning, Tiffany has assisted clients through the court-supervised probate process to transfer a decedent's assets to beneficiaries. Tiffany's dealt with issues including out-of-state fiduciaries, guardianship proceeds for transfers to minors, and non-U.S. citizen descendants. Similarly, Tiffany has come alongside grieving families to carry out the terms of the loved one's trust. Tiffany graduated cum laude from University of California, Los Angeles. She attended Loyola Law School in Los Angeles on a full scholarship as a Dean Scholar. Tiffany is an active member of the legal community and has served in the Chamber of Honor of the Honorable James V. Selena, is certified with the State Bar of California, and a member of the Orange County Bar Association. For 3 years, Tiffany taught a class on estate planning through UCI's Division of Continuing Education and frequently speaks on estate planning at various events throughout the year, such as today. On the personal side, Tiffany and her husband of 19 years, Randy, reside in Irvine with 3 children, Brandon, Wesley, and Carries. Tiffany is an avid runner and participates in races throughout the year. Tiffany and her family enjoy hitting the track, slopes, or beach, sometimes all in the same day. Very active. With that, I'm going to go ahead and turn it over to you, Tiffany, and you can take over from there.
Thank you so much, Josh. It is always such a privilege to be able to be partnering with Acronym and working with their clients. I have worked with them for over a decade, and I have personally seen the high caliber of service they offer to their clients, and to be able to join alongside them is always just a privilege. So today we are talking about an estate plan, and hopefully you have some background on estate planning, but I wanted to start off with a quote. And this is a quote that I came across this past week or so when I was reading a California Supreme Court case, and it really resonated with me, and it really should just be a plaque on in my office, because this is exactly what I do. And the quote is, "The right to dispose of property in contemplation of death is as old as the right to acquire and possess property, and the laws of all civilized countries recognize and protect this right." And that's what we're doing when we do your estate plan. We are exercising your right to distribute your assets according to your wishes, the assets that you guys have acquired through hard work and savings, and we just want to make sure that it goes to the people that you intend for it to go to. So before we actually get into an estate plan, or before we get into what we're going to really talk about today, I wanted to provide a framework, a foundation for how I want you to think about an estate plan. What is an estate plan? What are we talking about when we talk about estate planning? And what documents are involved when we work on an estate plan? I have this little thing on the side that says, remember the buckets. And if you worked with me on your estate plan, you might have remembered me drawing these buckets out. So here is a digital version of my quick presentation. So what we're doing is creating or updating your estate plan. When you come into my office, what we're trying to do is either create an estate plan for you or update your current estate plan. And what I want you to understand when we're doing your estate plan is who is authorized to manage the asset that you own. During your lifetime, you're familiar with who gets to manage your asset. If you're on title to a particular asset, like a 401k or your property, then you are the one who is authorized to deal with that particular asset. So for instance, if I have a 401k that my name is on at Charles Schwab, And let's say my husband says, hey, I want a distribution from that 401k. He can't go ahead and call Charles Schwab and say, okay, I want to take out $100,000 from my wife's 401k. Charles Schwab is going to say, you're not on title, buddy. You can't do that unless Tiffany has authorized you to do that. Likewise, if I were to do that to his 401k, I would also be turned down because I'm not on title to his particular account. People don't assume that spouses get along, actually. So if you want your spouse to have access to your account, you actually have to specifically authorize that. But generally speaking, if you're on title to a particular asset, then you're the one who has the authority to manage it. If you wanted to refinance a property that you and your spouse own together, then your signatures need to be on all the loan documents. And if one of you is unavailable, then you can't close that loan. So we are familiar with how we manage assets during our lifetime. And oftentimes when people come to my office to get their estate plan together, they are concerned about what happens to their assets when they pass away. They don't magically transfer to living people. Your name is still on title when you pass away. And the person who passes away is referred to as the decedent. So the decedent's name continues to be on title until something happens to transfer title to a living person, hopefully the decedent's beneficiaries. And so when we create your estate plan, we are concerned with how we transfer your assets in the event of your death. Okay. In your estate plan too, we want to address what happens in the event of your incapacity. If you're incapacitated, the law says that you don't have the legal capacity to have documents that you signed enforced against you. You didn't know what you were doing. So in the event of your incapacity, you need to be able to appoint someone who does have capacity and who is authorized to step into your shoes for any asset that you own and manage that particular asset for you. So in your estate plan, we're going to have documents to allow for this particular process. So as I'm talking about what we're going to deal with when we deal with your estate plan, you can see that we need to have an understanding of everything that you own, because everything you own will have a particular evidence of title, whether not everything you own, but like your property or your bank accounts. These assets will have a statement or a deed reflecting who is on title and therefore who is authorized to manage that particular asset. And all of the assets that you own are going to fit into one of these 4 buckets. The first bucket's the trust bucket. The second is the payable on death bucket. The third is a joint tenancy bucket. And the last one is the probate bucket. So lots of times people come into the office and say, okay, I've heard of probate, and all I know is I don't want to go through it. Amen. We never want to go through probate. I've done it, and I don't like going through probate for my clients. It's a already difficult time for them, and to have to struggle through court proceedings and pay all the money for not only court fees and attorney's fees, it's just a difficult process. And if you don't have to go through it, I beg you not to. So if you leave any asset that is in your individual name that doesn't have a beneficiary is in this probate bucket. And in probate, if you pass away, these assets are going to go through a court supervised process where all the assets that the decedent owned at the time of his or her death are marshaled, and an inventory is made of everything that this decedent owned. And in probate, all of the decedent's creditors, their debtors, their credit card debts, their mortgage payments, all of these debts that the decedent owns, unfortunately, they don't just extinguish because the decedent's gone, they still have to be paid. So after collecting all of the decedent's assets, then the courts takes a look at all the debtors or the creditors to see which one is a legitimate claim that should be paid from the probate estate. And then whatever's left over, if the decedent didn't have a will, the probate court is going to distribute and supervise that distribution to what we call heirs at law, who California law deems is the appropriate beneficiary of your estate. And so we don't want to go through probate. It's expensive, it's incredibly time consuming. COVID has definitely held back the court system, and things are even more impacted than normal. So let's keep assets out of this bucket. Let's not put assets in your individual name without a beneficiary designated. Many clients come into my office with assets in this joint tenancy bucket. And what that means is that at least 2 people are entitled to these particular assets, and usually the home, John Doe and Jane Doe, as husband and wife, as joint tenants. And what this means is at least 2 people are on title. And when you take title as a joint tenant, you're expressing your intention that if one of us passes away, the other one of us automatically assumes ownership of the entire asset. There's no probate proceeding when one person passes away. It does automatically, the surviving joint tenant automatically assumes ownership of the entire thing. However, when that surviving joint tenant is the only person on title, this asset is no longer in this bucket. It's now in this probate bucket. And when this joint tenant, the surviving joint tenant passes away, that asset is going to go through probate before being transferred to beneficiaries, and that's not something we want. Furthermore, what if both joint tenants pass away at the same time? Same thing, it's going to go through probate before being transferred to beneficiaries. So generally, I advise my clients to keep assets out of this bucket as well. And instead, what we want to do is transfer it into a trust. And instead of a property being owned, for instance, as John Doe and Jane Doe, husband and wife, as joint tenants, we're going to transfer title. So it'll be John Doe and Jane Doe, trustees of the Doe Family Trust. And the trust is going to be the first document in your estate plan. And it's basically a contract where there are parties to the contract, the grantors, who are John Doe and Jane Doe, the people creating the trust, and the trustees, the kind of officers of the trust who are authorized to manage the assets that are titled in the trust. And it'll dictate the terms of how the trustees should manage these particular assets. It'll say, while John Doe and Jane Doe are alive, they can do whatever they want with these assets. If John wants to go buy a Porsche, go ahead, take money out to do that. If they want to go on vacation around the world, take as much as you want. These are their assets. It's a revocable trust. They have complete control over everything in it. The trust is going to go on to say, well, if one of us is incapacitated, if John Doe or Jane Doe is incapacitated, we want our spouse to step into our shoes and manage everything in this bucket for both of our benefits. And if both of us are incapacitated, we have someone called a successor trustee that we trust to step into our shoes and manage everything in this bucket for us, use the assets in this bucket for our benefit. It'll also continue to say, if one of us passes away, what's going to happen to the assets here? Does everything go to the surviving spouse, or maybe a portion is going to be given to the children? However you guys want, because these are your assets. And again, if something happens to the second spouse, then the successor trustee, who is that going to be? Who can step into our shoes and distribute the assets that we left in this trust for the benefit of our kids, our beneficiaries, whoever you guys decide. And because we have a successor trustee supervising the distribution of assets to the beneficiaries, we don't need a court. We're saying we already got this. We don't need a court to step in and manage the distribution of assets to our beneficiaries. We trust this person to do that for us. So that's going to be the first document in your estate plan, and you can see that someone is appointed in the event to manage assets in the event of incapacity as well as death. And before I go on to the other documents in your estate plan, I want to go over this other bucket, the payable on death bucket. Assets in here include life insurance policies, 401ks, retirement accounts, IRAs. And these assets are ones in which when you open this account or when you purchased your life insurance policy, you were asked to fill out a beneficiary designation form. And what that means is when I pass away, I want my death proceeds to go to this beneficiary, or I want my retirement account, the balance of it, to go to this beneficiary. And now it's the financial institution's responsibility to make sure that that beneficiary designation is carried out. They're supervising the distribution to your beneficiaries. Again, probate is not necessary. We don't need to get a court involved. The other documents I want to go over in your estate plan are the power of attorney for financial matters. We were saying earlier, in the event of incapacity, the successor trustee can step in and manage the assets in your trust, but that person has no authority in his or her capacity as a successor trustee to manage anything outside of the trust. You got your 401ks, your life insurance policies, you may be eligible for Social Security, you may have tax returns to file, and someone needs to do this for you. So your power of attorney is going to authorize somebody to manage all of these financial matters in the event of your incapacity. And then your other document in your estate plan will be your healthcare documents. Who is going to make your medical decisions in the event of your death? And what are your wishes with regard to those decisions? Do you want to be kept alive by artificial nutrition, hydration, life prolonging procedures? So we memorialize your wishes in your estate plan. So just take a look at these buckets, and you can see that every asset you're going to own is going to fall into one of these buckets. And we want everything to be in the first two buckets. It's either titled in the trust Or if it's not titled in the trust, make sure you have a beneficiary listed for this particular asset. Let's try to keep assets out of the joint tenancy bucket, out of the probate bucket.
This is fantastic. So I think this is a great spot. We got a great question, I think, that really correlates with where we're at right now.
Okay.
But the question that came through, which I think comes up often, and it's what's the difference between a trust and a will, and why do you have one over the other? Or I'm going to add in there, or should you just have both?
You definitely should have both. And man, I actually took out the will in this presentation because I wanted to kind of focus on particular things that would warrant a change in our estate plan. So yes, the trust document you can see is under the trust bucket. And usually if you go into an initial consultation with me, I would also explain to you why you have a will. And that would usually come up over this probate bucket because the will is drafted for you in case you left anything in your probate bucket. No matter how diligent you are about making sure your assets are in the first two buckets, you might have forgotten like a checking account or maybe even your cars. And generally speaking, you don't have to transfer your cars into the trust, by the way. But what the will is for assets that you might have left in the probate bucket. And if you did leave anything in there at the time of your death, it will go through probate. Maybe there's going to be an informal procedure, but if it goes through probate, the judge is going to ask whether or not you have a will. And your will is going to say, if I left anything in this probate bucket, that was an accident, please transfer everything into my trust. This is particularly important if you have minor children, because if assets go through probate and your will doesn't say it transfers into the trust, if your minor children inherit these assets, then not only do you have to go through probate, you're going to have to go through a guardianship proceeding where someone has to be appointed as the guardian for those minors. Minors are not considered to have legal capacity, so they cannot own stuff. So someone has to be appointed to own it for them. So yes.
That's fantastic. Thank you.
Yeah. Well,
yep, feel free to continue.
Okay. So now that we understand what an estate plan is, hopefully, when do I need to update my estate plan? And really, your estate plan is written according to the circumstances at the time that your plan is written. We try to be as flexible as possible. By we, I mean me, and I think a lot of my estate planning colleagues. We try to make your trust as flexible as possible, but we can only plan for so much. And so changes in your stages in life would warrant a change in your estate plan. So let's say marital status. I would say anyone who is over the age of 18 should have some of these documents in place. There's a recent case, there's a recent incident that happened to a family in Orange County, in fact, who sent their son off to the East Coast to go to college. And unfortunately, their son fell into a coma. And the parents, of course, rushed out to the East Coast to talk to the doctors about their son's condition. Unfortunately, they also had to make some decisions for him because he was in a coma. He didn't have the capacity to make medical decisions on his own. But because he didn't have healthcare documents like a power of attorney or HIPAA authorization authorizing his parents to talk to the doctor about his private medical information, the doctors couldn't reveal everything to his parents. And his parents reported back that they felt it. They didn't feel like they understood his entire medical condition, but yet had to make decisions about his end-of-life care. And so, yes, anyone over the age of 18 have some documents in place. If that person gets married, revisit your documents, because maybe your parents shouldn't be your powers of attorney at this point. Maybe you should have your spouse step in and make medical decisions for you or help manage your finances in the event of incapacity. And maybe you want to benefit your spouse, perhaps. If you pass away, you want to make sure that your spouse is taken care of. And not only does your marital status matter in this kind of context, also matters because if you get remarried and you have brought children into the marriage, you have a blended family, there are strategies that we can use to make sure that some of your assets do eventually wind up with your children, your biological children. So marital status for sure is an important one, not only yours, but also your children's. If you have an outdated or an older trust, then perhaps your trust wasn't written in contemplation of your children's marriage. And if that's the case, then it might say something like, if me and my spouse pass away, my spouse and I pass away, everything goes to my children and maybe it goes to them outright. And now if my child is married and they receive a check for their inheritance, they can deposit it into an account that's commingled with their spouse. And is that what you intended? Did you really want your children to commingle their inheritance with their spouse? Or did you want their inheritance to stay with them? And there are ways to write your trust so that instead of giving the child the flexibility to commingle their assets, they have to separate their assets from their spouse. So in the event of their divorce, whatever you gave to them stays with them. Other changes in your life, birth or adoption. If you have more kids, usually your estate planning documents will say your children, the definition of children will include any subsequent children that you and your spouse have together. And so maybe the shares are going to be divided equally, as you probably wish for them to be divided. But maybe your guardians are not going to be the appropriate guardians when you have a brood of children. Maybe the guardians you selected were only going to be appropriate to take in 1 or 2 of your kids, but now that you've got like 5 or 6, maybe you want to consider other guardians, or maybe your guardians are older. So those kind of circumstances might warrant a change in your documents. If something happens to a loved one, incapacity or the loss of a loved one, that might warrant a change in your documents. If it's a loved one acting as a fiduciary, did you name them as a successor trustee to step into your shoes and manage the assets of your trust for your benefit? Did you name that loved one as a power of attorney or someone to make your healthcare decisions? If they're a fiduciary under your estate plan, you might have successors to help to step into that person's shoes instead, or you might not. So you want to take a look at your estate plan for that. Or was this person who's lost capacity or who is now not here, is this person a beneficiary under your estate plan? And does your estate plan contemplate the possibility of them not being there? Maybe a distribution was made to John Doe under your estate plan, and now that John Doe is not here, what happens to that distribution? It might be vague, your estate plan may not be clear, and it might result in some litigation in the future if that's not clarified. Changes in relationships, if some people have friends as fiduciaries under their estate plan, and maybe they're the trustees or guardians, and maybe they moved across the country, maybe they just don't talk to them, time changes things. So maybe those kind of relationships might warrant a change in your estate plan. I have a client as well who is considering a disinheritance, and that's because just changes with the ability to contact that beneficiary has led them to believe that maybe they shouldn't receive a portion of their inheritance. The changes in your life stages would definitely warrant another look at your estate plan. Changes in business interests. So many people are starting businesses nowadays, or maybe you have a business. And whatever that business is, if you own any share of it, it is an asset. And so think of the buckets. Remember the bucket. Your business interest is going to fit into one of those 4 buckets. And if you took title to those share certificates or the shares of stock or your membership interest in an LLC, if you took titles in your individual name, that interest is in the probate bucket, which means if you pass away, that interest is going to have to go through probate before being distributed to your beneficiaries. So what has often happened, actually in the last year or so, I've gotten many calls about business owners who passed away, and their families are calling me saying, what do I do? How can I access the business checking account? Well, you can't, because you're not on title, not on title to the account, not on title to the business. The account is held by ABC Inc., and now ABC Inc.'s president is gone. And so what you have to do is go through probate, and a probate court will appoint someone who can step into that decedent's shoes. And now, as the owner of these shares of stock, the shareholders can appoint a president to then access the bank account, wind it all up, and then distribute it according to the decedent's wishes. So if you have a business, it's really important to take a look at your ownership documents, share certificates, membership interest certificates to see who owns that particular asset. Or if you have partners, talk about a buy-sell agreement. Who gets the right to buy your interest in the business? I mean, partners don't necessarily want to work with their spouses or want to work with their partner's spouses, with their partner's spouses. So perhaps there's a buy-sell agreement that you should enter into to ensure that your partner has the right to buy your interest first. Okay, if you are selling an interest in a business and your previous estate planning documents had some specific distribution of that business, maybe you said, my son works for me and I think I want ABC Inc. to go to my son. And now you've sold it, and now there's confusion because you pass away and this company, the trust says your son gets ABC Inc., which is no longer part of your estate. So does he get something that is of equal value to ABC Inc., which takes away from the other children's shares. It's confusing, and so if you dispose of your business interest as well, it would be helpful to take a look at your estate plan to see whether or not there was specific mention of it in your documents. Changes in your net worth. So we're going to talk a little bit more about estate tax issues, but just briefly, hopefully, theoretically, living the American dream, you are increasing your net worth as you get older. Maybe decreasing it for a little bit while your kids are in college, but generally speaking, we're upward movement. We're hoping for upward movement in the net worth arena. And so at some point, you might come across estate tax issues. So what's an estate tax? We're familiar with taxes for sure. Income taxes we know of, it's taxed on our income. Property taxes we know are taxed on the assessed value of our property. Estate taxes are not those taxes, they're a different kind of tax, and they come into play when you pass away, and the government wants to know how much did you own at the time of your death. And if you have more, if the value of your estate exceeds the exemption, then you may owe a tax, and the current tax rate for anything above the exemption is 40%. The good news, though, is that the exemption is pretty high right now. It's 11.7 million. The bad news is there's a proposal to reduce that by at least half. So we always keep an eye on the estate tax issue. And if you are increasing in your net worth, an estate tax might be something that you want to minimize for your beneficiaries. And we can do some there's some estate planning strategies to help you with that. Changes in your net worth. If all of a sudden you do have a lot of money, and you don't need anyone else's money, you can talk to maybe your parents who you expect to receive an inheritance from to hopefully bypass your estate so that you don't have to receive their inheritance and pay an estate tax on that. Maybe you want it to go instead to your children who don't have anything to their name right now. And so you can do some pre-inheritance planning. You can use some things called powers of appointments to appoint your share of the inheritance to somebody else, perhaps. Post-inheritance planning, if you are already the recipient of inheritance, you have 9 months to disclaim. If you have found that because of your change in net worth, you don't need this particular inheritance, you can say, I don't want it, I'm going to disclaim it. And if you disclaim it, it'll pass according to that person's estate plan, and maybe it'll go to your children. And it'll bypass your estate, therefore bypassing any exposure from your debts to the estate tax. And what if your change in net worth also warrants a change in how your children inherit their inheritance? Maybe now all of a sudden, instead of inheriting, $10, they're inheriting $10 million or even $100,000 or $1 million. In any case, that changes the way that you want your children to inherit stuff. Instead of maybe outright with unlimited rights to withdraw, maybe you want to say, okay, they get their inheritance in a trust. And maybe, when we said that we can, the child can get a third of it at the age of 25, we were talking in the context of maybe $500,000. But now we've got $5 million. And what does a 25-year-old need with almost $2 million? So maybe you want to change those kind of distributions or those rights to withdraw from your children's trust that you created in an estate plan that was done years before your net worth was so high. So those are reasons also to change your estate plan or update your estate plan. I often get the question of, what if I acquire new assets? Generally speaking, if you want that new asset to be disposed of according to your current trust, meaning maybe your trust says, if I pass away, I want everything to go to my spouse, and then after my spouse passes away, I want everything to go to my children in equal shares. You may not have to change your estate plan. You just want to take title to that new asset in the name of the trust or name of beneficiary if you don't. And if you dispose of old assets, again, it's kind of the same example with the business. If you have a specific distribution in your estate plan for that old asset, maybe you have a property in Laguna Beach and you wanted that to go to your oldest child because they got married there. I'm not sure why. But in any case, if you had a specific distribution of a piece of property that you no longer have, let's update your estate plan so there's no confusion about how you want the rest of your stuff distributed. Okay. When else should I update my estate plan? There are new laws that come into effect all the time. I've been practicing for about a dozen years. I've gone through Bush, Obama, Trump, and now Biden, and with every administration there has been new changes in the law. some recent changes was in 2018, January 1st, 2018 was the Tax Cut and Jobs Act during the Trump administration. And this, so these laws that I'm going to be talking about did way more than just change estate planning. It did, income tax, corporate tax, they changed the rate on a lot of different things, but I'm just going to be focusing on how that might warrant a change in your estate plan. But this Tax Cut and Jobs Act, passed in January 1st, 2018, temporarily raised the estate tax exemption to $11 million. So I say temporarily because back in December 2010, Obama changed the estate tax exemption to $5 million, and that was supposed to be permanent. $5 million indexed for inflation. And so when Trump enacted the Tax Cut and Jobs Act, what he did was temporarily raise the estate tax exemption to $11 million. That's indexed for inflation, so that in 2021, the exemption is $11.7 million. And again, the state tax exemption refers to the tax that's assessed upon your death. The government again wants to see how much did you own, and if you owned more than if the value of your estate is more than $11.7 million in 2021, you owe a tax for anything above that exemption at about a 40% tax rate. So that was a temporary increase in the estate tax exemption. It was set to sunset in January 1st, 2026, and which that means at that point it would revert back to Obama era, $5 million indexed for inflation. That would be the estate tax exemption scheduled for 2026. That was the Tax Cut and Jobs Act on January 1st, 2018, and January 1st, 2020, there was the Secure Act. This is Setting Every Community Up for Retirement Enhancement Act. This largely affected retirement accounts, and it changed how it affected my clients was the distribution period. So if you're familiar with 401ks and IRAs, you probably save money and put money in there because you get this tax benefit, meaning you don't have to pay taxes when you put for anything that you put in that 401k or IRA. Instead, that money is taxed when it's distributed to you, and hopefully it's distributed to you in your retirement years, and theoretically during that time your income tax rate will be lower. So that's what people do with the 401ks and the IRAs, but the government at some time, of course, wants their money. So what they said is during when you have your own 401k, and even when you distribute your 401k or you name your spouse as the beneficiary of that retirement account, you and your spouse can distribute, or your spouse can recognize that distribution, can distribute the remaining balance of that retirement account over his or her lifetime, which means that they can stretch the distribution over a longer period of time, therefore recognizing less income every year. And what the Secure Act did was restrict that life expectancy distribution for certain beneficiaries. So yes, your spouse can still get that life expectancy distribution, but now your children who used to be able to get that life expectancy distribution, they now get a 10-year distribution period. There are some cutouts for eligible designated beneficiaries, which were for minor beneficiaries, but this affected my clients who had large retirement accounts, and now if they expected that their children is going to have to recognize income over 10 years, then that could be a larger distribution every year, and they wanted to plan for how comfortable they felt with their child managing that larger distribution. So that might have warranted a change in your estate plan. Other recent changes, Proposition 19 was approved by California voters in November 2020, effective February 15, 2021. This affected property taxes, and it really affected property taxes. Every time you have a change in ownership in your property, so whether it's you and your spouse transferring your home to your trust, or you and your spouse purchasing a new piece of property, every time there's a change in ownership, the county has an opportunity to reassess your property. And in California, that very likely means you're going to pay more in property taxes because California real property goes in an ever appreciating trend. So what we want to do usually is to avoid reassessment. And for transfers to a revocable trust, we qualify for an exemption to reassessment that applies to transfers to a revocable trust. So when I have a client whose home is currently in their own name, we want to transfer it to their trust, and we file a document that claims that exemptions for that particular transfer. Before Prop 19, there was also there was also an exemption for transfers between parent and child. so that a child can pass the property to the parent, a parent can pass the property to the child, and the property taxes would stay the same. They would not be reassessed. But Prop 19 that was marketed as a proposition that would help fire victims and senior citizens. They were supposed to do that by raising property taxes. And in particular, parent-child exclusion was restricted to transfers of principal residences that the parents lived in to children who will then use that property for their own principal residence. Anything else is going to be reassessed. And this is affecting many of my clients. Before February 15, 2021, before this came into effect, lots of people were trying to transfer their properties so that their children do not get reassessed. You can imagine people who have had their homes since the 50s, 60s, 70s, very low property tax assessed value, and they anticipated being able to transfer that home to their children in the future when they pass away. But now if the child were to get that property, they would be faced with an assessment and new property taxes that they can no longer afford. And unfortunately, in many of these circumstances, the child is going to have to sell the property. They can't keep it. So that really affected a lot of people, especially here, or actually in California, especially here in Orange County. So that was Prop 19. And you might have heard that the House Ways and Means Committee have made some proposals to the tax law, and that was back in September 13, 2021. And it's called the Build Back Better Act. Try saying that 10 times, Build Back Better. These modified rules, this act modifies rules relating to retirement plans. Retirement plans, that's one provision of it, or some provisions of it, where if you have a mega retirement plan with more than $10 million and you're making more than $400,000 or $450,000 annually, you might be affected by these rules. This really affected, or at least the proposal is proposing to affect, something called grantor trusts. And these trusts are a particular type of trust that some higher net worth clients like to employ in order to take assets out of their estate and therefore minimize their estate tax exposure. And so what this proposal is now doing is saying, no, if you have a grantor trust, it's an irrevocable trust. Yes, it is, but we're still going to include it in your estate. It's not going to work to minimize the size of your estate, which is going to be looked at when you pass away to determine whether or not you owe an estate tax. That is going to be limited, and so we're waiting to see what is going to be enacted from that particular proposal. Another thing that is being proposed is valuation discounts or lack thereof. And this is another estate planning strategy where instead of gifting property, you put it into a partnership or an LLC and you gift those interests instead. And instead, the proportionate value of that interest is lower. So essentially what you're doing is gifting less and therefore chipping away more slowly at your estate tax exemption. That is proposed to be gotten rid of, or will be getting rid of. And then another major change in that's being proposed and is probably going to happen is the termination of that temporary increase that the Tax Cut and Jobs Act had for the estate tax exemption. So remember earlier we were saying that Obama had it at $5 million, Trump doubled it to $11 million, and now Biden is proposing to terminate that temporary increase and having it back to 2010 levels, which is $5 million. Indexed for inflation, I hear, is about $6.2 million for 2021. That would change dramatically as well.
I was going to say, have we heard anything about the limiting effectiveness of grantor trusts for existing grantor trusts? Do we know if those will get grandfathered and it'll just be new irrevocable trusts moving forward?
It's so, because they definitely want to capture any kind of payments that are going to be made after the enactment of this law. So what's being proposed is, for instance, if you have an ILIT, an irrevocable life insurance trust, where you have these life insurance proceeds, but you didn't want it to be part of your estate. So you create this irrevocable trust to hold your insurance policy. Mm-hmm. They're saying any payments of the premium after the effectiveness of this date will make it such that a pro rata share of that those insurance proceeds are going to be counted towards your estate. So wow. Yeah, it's Yes, it's kind of a very confusing time for estate planning attorneys. It's definitely, everything is up in the air. These very traditional estate planning strategies may not be as effective as we were hoping for, or as they were before. Okay, and so we're talking about another reason to update your estate plan. If there are changes in the law that might warrant an update. If you moved out of the state, please get an estate planning attorney in that state to look at your estate plan. Every state law is different. These estate plans, these trusts are governed by the laws of the state in which you live at the time of your death. For instance, what can be different? There are only 12 states that have estate taxes. So not only would you be subject to the federal estate tax that we've been talking about, the $11.7 million estate tax exemption, or the tax that would be assessed for anything over the $11.7 million. Some states have a state estate tax, maybe at $3.5 million, maybe at $5 million, which means that if you pass away with assets over that state estate tax exemption, you're not only subject to the state's estate tax, but maybe the federal estate tax as well. Anyways, in California, surprisingly, we don't have an estate tax yet. And so the documents that I draft don't contemplate an estate tax. You would draft it very differently. We would draft it very differently if we did. Formalities are different. In California, we only need 2 witnesses for your wills. There are other states that require 3 witnesses. So your will may be unenforceable in a different state. In California, we are a community property law state, and we are one of 9 states in America that is a community property state, and our trusts are drafted in accordance with community property laws. And so if you move to a non-community property state, otherwise known as a common law state, you're definitely going to want to take your estate plan to an attorney at that state. All right, some examples of issues arising from some of the outdated plans. I can kind of go through this, or we can go on with some questions. These are just issues that I've come across from old estate plans.
We do have, we have about 15 minutes left.
Mm-hmm.
We do have a good number of questions.
Okay.
So it's up to you if you prefer to go through these, or if you want to breeze through them kind of quick, and then we can
I'll breeze through a few of them.
Okay.
So if you have, so the first one is a trust mill trust, a do-it-yourself trust. I won't name any names, but there are common platforms in which you can create your own estate plan. And I've seen many issues with these. First of all, people forget to name their spouse as their first fiduciary. It's not assumed that your spouse can step into your shoes if you're incapacitated. Another thing recently was the loss of capacity of one of my clients. Her spouse lost capacity. Unfortunately, the documents didn't contemplate a change of their estate plan in this particular circumstance, and she is stuck with the trust that is 20 years old, which says after her spouse passes away, everything goes into an irrevocable trust. I'm not quite sure why it said that, but that is definitely not what she wishes for. Clauses need to be updated. I'll skip over that one. I had a case where there was a vacancy in the trustee because this trust was 20, 30 years old and all the trustees had passed away. And in that circumstance, we actually had to petition the court to have my client moved in as the trustee for that particular trust. There are stale trusts where people don't administer trust after one person passes away. When you don't do the meeting, there are terms that need to be carried out. When one spouse passes away, the trust says what to do, and those terms need to be carried out. It's a lot cheaper than probate. It's a lot more efficient than probate, but it still needs to be done. If you fail to do that, you're probably going to lose out on some really important tax opportunities. If you have a trust that was drafted before 2010, please take it to an attorney to have it updated. A lot of these trusts, people come in with their pre-2010 trust saying, everything was supposed to be left to me. Yes, but you don't realize how, what it says is it's left to you in part in a revocable trust, in other part in an irrevocable trust. A lot of clients who are surprised to find this out, and the only way to modify that is through a court. I think I touched on the big ones.
Okay. That was all, I mean, it's really, really good stuff. So I know it was a lot of information, but I mean, it's really, really good information that you provided to us. So what we're going to do now is we're going to go ahead and go through, and do you want to turn your camera on?
Oh, is it not on?
No. Oh, did you?
It's been on the whole time.
Hit
green.
There you go.
I'm sorry.
Perfect. Okay, and then I'm going to turn mine on. Here we go. Okay, very good. All right, so we're gonna go through here. I'm gonna read off some of the questions that we have. Let's see here. There was one that I thought was a good one to kick us off because I thought it was, okay. So first question for you is, we do not have children to inherit our assets. Does disposition of assets after we have both passed, unless specified in a will, default to a surviving family member?
If you don't have an estate plan, if you don't have a specific distribution of your assets in estate planning documents, and your estate will go through probate, California law already provides an estate plan for you. If you don't have children, it says that your assets go to your parents. If your parents are not here, it says your assets will go to your siblings. If you don't have any siblings, there is a hierarchy of people that California law has deemed important enough to inherit your stuff. So someone will inherit it eventually.
It's not the first time it's happened.
Yes, my first probate matter was somebody who died without a will, didn't have any children, and it was his siblings that inherited it.
Okay, so here's another one. If your trust is very old, is it possible to just start a brand new one versus amending the old one?
That's a great question. I like to restate the old trust because I'm not quite sure whether or not you have any assets in the name of the old trust. And if you do, I don't want to have updated the trust disposition for that particular asset. Because again, title controls. If you have any asset that uses the old name of the trust, then it's going to be disposed of according to that old trust. So what I prefer to do is entirely restate that old trust. I will use the same name so that you don't even have to change title to any assets that were in the name of that trust. And we just restate the trust. It's an amendment of the entire document.
Okay, so for the next one, we have for single parents with an estate plan. Once your child turns 18, do you need to update your estate plan due to no longer needing a backup legal guardian, or does the trust automatically take into account once the child becomes an adult?
Yeah, you don't have to update your trust because if your child doesn't need a guardian anymore, those guardianship papers don't come into effect. They can be their own guardian. There's not going to be a guardianship proceeding in which those guardianship documents would be submitted. So you don't need to update those documents, but the trust doesn't automatically say that your child who now does have legal capacity will step into the fiduciary shoes, perhaps as like a successor trustee or as a healthcare power of attorney. If you want your child to make those decisions for you, to step into that role and under your estate plan, you're going to need to update your estate plan to reflect those wishes. Again, the law does not assume that you have a good relationship with your child. It doesn't assume you have a good relationship with your spouse. You need to specifically name them as people you trust to step into those roles and manage your assets for your benefit.
It's funny, you almost forget to think about that piece of it, right? Just think about it, the transfer itself after I pass, but what if I'm incapacitated?
Yeah.
Okay, perfect. So let's continue on here. And we still have about just shy of 10 minutes. So if anybody has any questions that they want to submit, please feel free. We have a few left in here. Is there an easy way to be notified when a new law may affect your trust or assets? I will try to stay up on these new laws and proactively ask my financial advisor. Good call.
Yes.
But I could easily miss some of them.
Yes. In fact, actually, I forgot to go through my last slide, which does say to call Acronym. For sure, I know Acronym would get you guys on the updated trend of legislation. So definitely call Acronym. Is there an easy way? I don't know. You actually have to proactively go look for it. You have to look, I don't think, Channel 5 News is going to cover the Build Back Better Act.
Sure be.
Yeah, I know. And I mean, even CNN will have a certain slant to it. I mean, you really need to look for it. You can call our office. You can call Aprium. I tried to send out, when the Secure Act passed a year and a half ago, I sent out a marketing newsletter to update people, financial advisors, about this particular legislation. So hopefully your attorney is up to date on what's going on.
Okay, next one. What is involved with changing an irrevocable trust to a revocable one on behalf of easier bookkeeping?
Oh, I'm going to go with it depends. It depends really, because it depends on the irrevocable document. Irrevocable means you can't change it, but maybe someone was given the power to alter it or substitute properties. Someone called a trust protector or trust advisor. Some irrevocable trusts are written so that there's someone who can change your trust to be as flexible as possible. There are limitations with regards to how much can be changed. Changing an irrevocable trust to a revocable trust, that doesn't usually happen in an irrevocable document. Usually you're going to have to transfer assets out of the trust into a new one. That's too big of a change.
Yeah, I mean, they really don't want you to have much control over that irrevocable trust.
I mean, there's a reason for the irrevocability of that trust, and so they don't just allow you to pull a trigger or flip a switch and say, okay, it's revocable now. So usually the reason is to keep assets out of your estate, and if you have any control over those assets, they're going to bring it back into your estate and be subject to the estate tax.
Perfect, thank you. Okay, so could you briefly talk about why cars are not typically in a trust?
Okay, well, if it's like a fancy car, then maybe you should put it into a trust. And I don't really know enough about cars to say what constitutes a fancy car, but let's say if it's worth more than $100,000, you should probably put it into a trust. Anything less than that, you can go to the DMV, and the DMV actually has an affidavit that you can fill out, and it basically says, I swear that I am the successor of interest to the owner of this vehicle under this owner's will. And so if you are that successor of interest, who is usually the trustee of a trust, like I said, the will's purpose is to pour over anything left in probate to your trust. Then you fill out that affidavit, you submit it to the DMV, and title is transferred to you.
Perfect.
Yeah.
One of these is a special request that we remove the slides so they can just see us on full screen.
Oh, okay. I feel like I wasted all my gestures from earlier. I didn't realize that.
Do you know how to do that?
Oh, let me see. I'm sorry, I don't. Is it just?
So do you see right there, that one?
Okay.
No, you're fine.
I'm technologically challenged.
Hey, we're just accommodating our special requests here. So
there you go.
Let's see here. Should a single person create a trust if own property or have a certain net worth?
I mean, I have people who are single, and even if they don't own property, I tell them it's a case by case basis. If you don't own property, if you don't have certain assets that would warrant a trust, I would say let's start with a will and make sure we have everything with a beneficiary designated on it. So if you just have brokerage accounts or retirement accounts, let's put a beneficiary on those particular assets. Let's make sure none of those beneficiaries are minors. Again, minors do not have the capacity to own stuff. If they inherit anything, it goes through a guardianship proceeding. So if you're single, the question is whether or not you want a trust to own stuff. Yes, if you have property, you definitely should get a trust. That is to avoid probate. Pieces of property are, in California in particular, are always going to warrant a probate process. Not only a short informal proceeding, a court will go through an entire probate proceeding to distribute that asset to your beneficiaries. It's just too big of an asset for the court to assume that you wanted it in a trust or disposed of in a certain way.
Okay, with 4 minutes to go, we have our last question that we're going to get into here. And this one was actually sent to me prior to the event. Mm-hmm. So love it when we get pre-submissions on questions on things. Everyone, please feel free. Any future events we have, send me an email. Let me know what your questions are. All right. So with this one, a little in depth, right? So it says some countries are governed with economic plans that are more in the decades duration. The United States seems to have a new economic plan with significantly different rules with each new administration. Trust definitions can be influenced by these plan changes. In the US, are we doomed to this frequent cycle of death and rebirth with necessary revisits to trust attorneys? Or is there some hope for lasting changes to trust language that will help make the messy politics just go away?
I think messy politics will exist so long as we have people who can vote. Well, I swear I'm not, advocating changes in the law just so that I can consistently have a job. There are changes to the law, significant changes to the law with every administration. Like I mentioned before, Obama, in Bush's administration to Obama's to Trump's to now to Biden's, and every administration has different priorities, and it usually involves taxes. And as much as we try to be flexible in our trusts, we can only contemplate so much. And so part of the reason why I would definitely take a look at your trust when there are major changes in the laws, because if things like a major tax exemption or the estate tax exemption goes up, we're trying to take advantage of that particular law, especially when it says it's temporary. So when that law ceases to exist, yes, some of these opportunities are going to cease. But the good news is that these laws usually affect higher net worth, maybe like 4 or 5% of the wealth in America. It may not affect you in particular, but 2010, like I said, pre-2010 trust definitely should be revisited, because that affects pretty much every trust I've seen before that was drafted before 2010. So in answer to your question, I'm sorry, I think the answer is yes. You should probably take a look at your estate plan when there are major changes to the law, and we can only do so much.
I think it's the same answer when it comes to financial planning, right? If there's major changes in your life from a financial standpoint, we should always be reviewing the financial plan. So with 2 minutes to go, I'm going to go ahead and wrap us up. First, I want to thank Tiffany, our guest speaker. The information has been tremendous, so thank you so much for taking the time to join us.
Thank you.
With that, Tiffany, again, thank you.
Thank you so much. It's such a pleasure.
And thank you to the Aprium family for joining us.
Thank you so much.
Bye, everyone.
Bye.